Can anyone hear me?
I can hear you. Good evening.
Okay, that's fine. Good evening, everybody. So it's just few minutes to 6. Okay, 6 already. So I'll be your moderator for today. I am Sophie Ayobami, and thank you all for joining. So moving forward, I welcome you all to week 5 of our mentorship and internship program. We're almost rounding off the quarter, and I'm glad we all have been doing well. Um, So to the next slide, I would love to introduce you to our free legal clinic for creative entertainers, athletes, innovators, and startups. Um, we we at Gypsy offer free consultations and contract review to whoever is interested. So you could also share with your networks, whoever um would really need our legal services. So it's also free. So we do not collect money for it. So you can get consultations with professionals who are in this field already. So it's a nice opportunity to have for yourself and to share with your networks. So thank you very much. So moving forward, I would love to introduce our mentors for this week. We are having 3 mentors on our program today. So firstly, Mrs. Omotayo Abiode. She's the founder and lead consultant at My Digital Lawyer, where she uses her experience in intellectual property and entertainment law to educate and enlighten creatives and entrepreneurs on how to legalize and protect their brands and innovation. She has a master's degree in intellectual property law and policy and has completed several certifications in intellectual property with international organizations, including but not limited to the World Intellectual Property Organization. Mrs. Omotayo, also widely known as My Digital Lawyer, regularly advises and represents a wide range of brands within and outside Nigeria on transactional commercial issues, including basic and technical legal issues surrounding intellectual property, media, and entertainment, with about 10 years post-call experience and about 5 years active experience in being an, okay, sorry, okay, and 5 years active experience in being an IP lawyer and tutor. So I'll stop here for now. Her profile is really long, so you could actually go through the flyer and learn more about what Mrs. Omotayo does. And moving forward to the next person for today is Mr. Adedunmade Onibokun. Mr. Adedunmade Onibokun is a lawyer and author whose legal practice focuses on corporate commercial law with a specialized focus on art law. He is the managing partner at Adedunmade Onubokun and Co. and general practice firm and leads on matters across different sectors in Nigeria. Adejumed is also the founder of Legal Nigeria, a justice innovation startup that is making access to justice easier for users, lawyers and non-lawyers, by allowing them access legal information, legal services, and an online dispute resolution mechanism to help parties negotiate and resolve disputes. Legal Nigeria also helps lawyers advance their legal careers as well. So you could also go through Mr. Didumit's flyer to learn more about his profile. Next on the program is Mr. Sheyi. Mr. Sheyi Arowasebe is the principal partner at Dilex Consult, a corporate and intellectual property law firm based in Abuja, Nigeria, serving clients across the country and globally. The firm has advised hundreds of clients in the formation and maintenance of corporate entities and also safeguarding the intellectual property of individual and corporate entities. He is a facilitator at the Intellectual Property Institute Nigeria, where he teaches trademarks and copyrights. Sheyi holds a Master's of Law degree in Intellectual Property Law and Policy. He is also an alumnus of the prestigious Lagos Business School. So thank you to our mentors today for being on the call. So without wasting further time, we'll be moving to the presentation of our first speaker, Mr. Adedun Maid. Please, the floor is open for you to share your insight and knowledge with us. Thank you very much for joining the call, sir.
Hi everyone, good evening. I hope you can hear me clearly.
Yeah, good evening, sir. We can hear you.
Okay, thank you so very much. First off, I'd like to apologize. I'm not going to be on the spot for too long because I'm actually speaking at the Creative Law Summit. And I just took time to just step aside from activities of this evening of the day actually to just come and hold the session. I hope you forgive me if I don't stay to the very end. I'm not sure I'm going to this presentation. I humbly apologize for that. I hope that's okay. I hope that's okay.
Yes, sir, that's fine, sir.
Okay, thank you so very much. Then please, I requested that someone will share my slides and please be kindly brought up. Great. Thank you so very much, guys. So, first off, I want to just give a thumbs up to the mentees who have put together their presentations. I've had the opportunity to go through it, and I feel you've done a good job so far. My presentation is just going to speak to a number of issues that you have not discussed already. So, first of all, just let me share, I have an amazing passion for art. Really, I kind of put my practice into that, So, when I became a lawyer, I started into the law practice. I realized that they were not getting the kind of protection that they needed. They were not getting they were not understanding the legal framework that they require to help my businesses thrive. I know that solution is there. So, we dedicated a lot of my time to outlook in order to help build the community, in order to see my artists thrive, and in order to just help develop that framework for outlook. You agree with me that uh, the music industry has grown a lot. The film and media industry has also grown a lot, but the art industry is lagging behind. So I'm one of the stakeholders in this industry and one of the people who is trying to drive it. I'm just happy to have the opportunity to share a little bit with you guys this evening. So without much ado, can we just jump right in, if that's okay? Can you kindly help me show to the next slide, please? Great. So from your research, I'm sure many of you already know what copyright is, right? And I'm sure you also know what intellectual property is. But today's focus, because we're talking about photography, we're going to be talking a lot more about copyright. The focus will actually be on copyright and not the others. I'm just going to pull them out just so for research purposes, you can read up on them later. We have trademarks, we have patents, we have industrial designs, and of course copyright. So it's important to note that copyright law is designed to protect creatives, protect creators. So who is a creator? The simple meaning of the word, sound that creates you, right? So we have creators in the art industry, they create art and painting. We have creators in the music industry, create the songs, and the producers that create the beats. And we also have them in the film and media industry, people that write the script, things like that. So the copyright law literally protects creators and it protects the expression of ideas and not just the idea itself. So what that means is if I have an idea to create a painting, right? The idea is in my head. I'm not expressed it. When I express it is when I put it on canvas, right? And that is when it becomes an expression. That is when it is protected, right? But if it's just an idea in my head, nobody can see it in my head, so that doesn't make exceptions. Section 1 of it is in the copyright. Helps us to define what can be copyrighted, what can be defined as a text. So here you can see we have
Hello,
something.
sir.
Yes.
Sorry to interrupt, sir. But your voice isn't too loud, isn't too clear. We can't really hear you clearly.
Okay. Is this a bit better?
Yes, this is better.
All right, great. I'm sorry, I'm in a public place, so I'm trying not to raise my voice too much. So yeah, you can see that paintings, drawings, woodcuts, engravings, maps, sculptures, photographs, works of architecture, works of artistic craftsmanship. And those are the things that are protected by copyright. So can we go to the next one, please? Next slide. Next slide.
Sorry, my screen is frozen. So let me try and reshare it again. Sorry about that.
Okay. So while we're waiting for the screen to pick up, just let me ask a question, and I'd like someone to answer me. If you go to an event, right, let's assume you go to a wedding ceremony, and someone takes a picture, who wants the copyright in that picture? Is it you or the person that took the picture? I'd like someone to just unmute their mic and answer quickly. Thank you.
The person that owns the is hello, please can you hear me?
I can hear you clearly. Please state your name as well. It's Musa, right?
I'm Peter. Everyone needs
Hi, Peter. Yes, so you were saying.
So I said it's the photographer that owns the work, not the person that contracted the photograph.
Exactly. Except there is an agreement that says that it's the person that commissioned the photograph that owns it. But you should also not mistake that for person in paid employment. So anybody who is in paid employment, right, and who takes a picture by nature of that employment is the employer that owns that picture. You have to be careful not to mistake that. So yes, you have rightly said it. The person that takes the picture is the owner of the copyright. And this is what I'm explaining here, right? Um, because the creative part of that expression is owned by the photographer. Can we go to the next slide, please? Great. So, there's a thin line between photography and art as it regards to copyright. Well, let's talk about photography first. So, when the camera was invented, the US Supreme Court, it's important to note that the US is actually one of the major drivers of copyright law in the world. They are the ones that really started it, way back. So a lot of copyright laws, a lot of copyright history can be traced to the US, and a lot of cases as well can be traced to the US, especially globally relevant cases can be traced to the US. Over time, the US court has established that a photograph is protected under the copyright law because of the originality behind it. And which quote is next page. Yeah, so I discussed this earlier when I said that copyright does not protect ideas, facts, or concepts, but it protects the creative expression. The courts in the US are even gone as far as to say that the particular things that make up the picture are copyrightable. That is not just the picture in itself, but also maybe the elements of the picture, the style of the pose, and even the direction of the photograph. All this are copyrightable, right? The scenes, the props, the camera angles, all this concept put together are copyrightable, right? And there's a case here that I'm cited to the versus Miller, where the court emphasized this point, and it stated that photographic elements are copyrightable, which include the photographer's background, lighting, positioning, timing, things like that. All the elements that make up a photograph are copyrightable. Next question. Yeah, so my slides are going to be discussing a lot of case law or a lot of disputes that are happening, mostly between photography and art. So mostly between photographers and artists. And the very first example is this case of Andy Warhol versus Goldsmith. So I don't know if anybody knows this artist in the background. His name is Prince. Do you know him? Just say yes if you know him. So that's if you do. Do you know him?
Yes, sir. Yes, I do.
Okay, great. So a couple of years ago, right, someone took a picture of Prince, right? And licensed that picture to Vanity Fair, a magazine. Gave them the license to use that picture as the cover, you know, of their magazine. Now, the magazine in turn contracted Andy Warhol, right, to create an image from the magazine. If you kindly scroll to the next page. Yes. So this particular picture that you can see now, this is the picture that was created by the artist. This is the image, right, the art that was drawn from the picture by the artist that was used on the magazine, right? Which was fine because they had the license to use it. But what they did not know is that, can we go back to the previous picture, to the previous slide? Right. What they did not know is that the artist has created other images from that one picture. And the artist did not tell them, he just kept it himself. But when Prince died, right, the artist now released those pictures. And it was at that point that the owners of the original license sued him. And they sued him on the grounds that the other pictures he created were based on the photographs that they owned the license to. And that they only gave Vanity Fair the license to use the photograph on their magazine. This was years ago. This was like in the 90s. Prince didn't die until like 2000s, right? So this was like 16, 20 years after that license had been given. And they sued, they sued the artist claiming that they did not seek their permission. They did not get the license from them before he created this other image. The artist tried to defend himself. He tried to say, no, it was transformative in a certain way, and it was not an infringement of the copyright. But the courts did not agree with him. And that's a very good point on what transformation is. And that was one of the cases that put to test what is meant to be transformative. So I tell a lot of artists, right? You go online, you see pictures of people who people just post their pictures online. You now take that picture and create art out of it. And I always saw that you can be sued, except you completely transform the art that it's completely different from the right? So it's very important. Sometimes in the future, you might have a client who is going to want to do something like this. It's important you do not you do not forget this principle, right? Let them know that it must be transformative in itself. You cannot just copy something without getting added right. And it's important to know something, right? Nobody sues a poor person, right? If I'll give you a classic example, a local example many of us might. So we know people who are bricklayers, right? People who are carpenters, right? People who are plumbers, right? Have you ever heard someone sue them? No, because there's no point in suing them. They don't have the money to even pay you in cash. In fact, the money that you're going to use to sue them is going to cost you a lot. And what are you going to get from them? So nobody's going to sue you until you make a lot of money. That's why some creatives say, oh, but I've not made a lot of money yet. Nobody's going to sue me. But what happens if 10 years, 15 years, 20 years down the line, you make a lot of money from that? You'll be surprised the person that has anything is going to come at you, especially when you have a lot of money to come to you. That's why, as a lawyer, I've seen people who say they want to sue banks. Why do they want to sue banks? Because they believe banks have a lot of money. They believe, oh, if I sue this bank, I can make a few millions, from them. So people always come at you when you make money, right? So if you make money and you took I seeing some IP, next time I will be sure that that person is going to come for you because they've seen the green, they've seen the dollar signs, they've seen the naira signs, and they're going to come for you. So this is an example of what happened. You can read through the context of the case. I shared a lot of the context of the case and the medication and portfolio. Right. So on the way forward, use the orthographers, use the unauthorized use of Lingo Smith's photograph for the music artist prints to create several silk screen prints. By the real foundation claims that these existing photographs was highly transformative, but like I said, the court did not agree. I will go to the next slide, please. So this also talks about the overall case. I'm going to share this slide with you. I think the organizers have it already. They can share it with you so you can read some more about the case. Let's go, please. Next slide. Excuse me. So this just gives a more detailed background of what happened. Will you believe that the picture was licensed in 1981? That is when they licensed the picture to the Vanity Fair. And they did not discover that infringement until 2016. Imagine the time lapse in 1981. That's a long time, many years. But that just shows that infringement can still be held against 10 years, 2 years, 20 years down the line. But I don't just it and nobody told me yes. They not sue you because they cannot sue you in the future. So it's cool. And what that is important to note is that the Supreme Court just gave its final decision on this picture in 2022. So imagine 1981, 2016, 2023. Can you see how many years that is battle? From started to when the Supreme Court made the final pronouncement. Can you see how many years that took? That just highlights my point that be careful. Tell your client to be careful, not to infringe on people's rights. The fact that they've not been sued now doesn't mean they can't be sued tomorrow. All right, can we go to the next slide, please?
That's not finished now. No.
Next slide, please. Yeah, so that's what I'm saying. May 2023, that's when the Supreme Court made the decision. So you can get to read this as well later on. Next slide, please. This is another interesting case. Many of us will know LeBron James, the footballer, right? He was playing ball. He made a very nice slam dunk, and the photographer took his picture. The name of the photographer was Stephen Mitchell. The baller saw the picture, liked it, and posted it on the socials. Just to show people, hey man, that my game was nice. That my dunk was really classy. And he posted the picture. He believed the photographer did him. A lot of people don't understand that people can sue you for using the picture of yourself. And a lot of celebrities have experienced it. Beyonce, Smith, a lot of them have experienced it in the past. So it's important as you're growing in practice, as you're going to learn, that if you have clients in this regard, it's important to tell them. The fact that it's a picture of you doesn't mean you have the automatic right to use it. Now, when in our country, Nigeria, right, a lot of people may not be suing like this, but copyright and IP awareness is growing. A lot of people are knowing their rights. A lot of people are knowing what entitled to stuff. So they can sue them. Back in the day, it would have been strange that it is my picture, I am suing you. It sounds worse to some people, but that's just the law, right? And the photographer sued for $150,000 for each time James used the image. Eventually, they were able to reach a settlement out of court. So that is one more thing about copyright issues. There's a lot of out of court settlements. right? That happens. A lot of people just don't want to go to court, and they don't want to leave their chance in the court. They just want to settle out of court. I particularly had a client who advised us to represent them in a case in court. They had infringed, or it was alleged that they had infringed on the rights of the photographer, and the photographer sued them. And when they approached my firm, and we went through the case, we went through all the facts of the case, I literally just told them, you know what, guys, just settle this thing out of court. You know, it doesn't worth the backlash. You are such a big company, the photographer is such a small photographer. When the news goes public, you know, you are not going to come out in a good light. So aside from the issues of the infringement itself, you have to understand that there are also other issues centered around business. So that's why you have to have a good understanding of your client's business. You have to have a good understanding of the space where your client works. And you also have to have a good understanding of what the public feels on issues like this. So yes, so this was a case of James, the basketballer. Scroll please, next page. So this is another case, Blanche versus Oops, right? The artist, Jeff Koons, had used, so this is what happened. Blanche had a magazine, right? Jeff Koons now printed a picture and used the painted the cover of that magazine because there was a picture on the cover of the magazine. He painted the cover of that magazine in the background of his work, of the artwork, right? Like, and they sued. They sued and said he infringed on the photograph, on the right in the photograph. But the court in that case held that his use of the photograph was transformative, you know, because he just added it to his painting, not as if that was the central piece of his painting. He just added it as a background in the painting. There were other things in the painting. So it was kind of like a transformative use. Again, he made it totally different. So the court held that that was transformative. But it's important to note at this point that transformative use is on a case-by-case basis. So because the court held that one was transformative, doesn't mean that in your case, or in your client's case, the court will hold that it is transformative. The elements of each case are examined and the elements of each case is discussed, right? So next slide, please. Yeah, so this is just tips for you. It's important to know expression of ideas. We've discussed this already. Copyright protects the expression of ideas. Then visual art, natural elements play a significant role in the creation of an artist. Right, so familiar symbols, color variations, typography, lettering, all those things are important on a case-by-case basis, right? Nonetheless, copyright law safeguards the expression of these non-protectable elements. And I'll speak more to this on the next slide. Next slide. Great. So this is a piece of work by an artist called St. Lyons, right? He claimed that this image of the, who will tell me what this is called? The name is somewhere on the screen. So if I just unmute that mic, I'll tell you what this is.
A jellyfish.
Exactly. What is your name, please?
Adeyemi Olajumoke.
Adeyemi, thank you so very much. Okay. So it is a jellyfish, right? And the artist wanted to copyright this image of the jellyfish. But the court felt that it is not copyrightable because there's nothing unique about it. He was saying, oh, you know, the way the tentacles of the jellyfish were, and they were like, no, this is how a jellyfish moves. Okay, for instance, right, if you take a picture of a bird flying, right, there are two copyrights in it. There is the picture itself, which is the expression, Then there's the bird flying. You cannot copyright the bird flying. Why? Because birds fly all the time. That's what they do. It's nothing new, right? It's a natural phenomenon. So you cannot copyright that. If you see a dog running and you take a picture, you can own the picture, you can own the copyright in that picture, but you cannot say you want to copyright the elements that is the dog running. Because dogs run all the time, that's what they do. So that itself is not copyrightable. That's what I said I was going to explain this as regards elements in copyright. Next slide, please. So I'm sorry that I'm just trying to rush through all this. Like I said, I'm trying to get back to the sessions here where I'm a speaker, but I hope that you find time to really read through all the information that I've prepared in this slide just for you to learn and for you to have a better understanding of copyright law as it's on the thin line between photography and art. That's what we're trying to examine here. Yeah. So next slide, please. Yeah, so these are more copyright issues in the case of Herbation Plantation Co. It was held that a copyright was issued. So this speaks to the issue of transformation, right? If I take a picture, okay, right now, I'm speaking to you, right? And if you take a screenshot of my picture, me, this suit and tie and jacket, and you're an artist and you want to paint it, right? If you transform it and make it different, for instance, my hair is a little bit low. Imagine you drew in the same picture, but you drew my hair wearing a hat. Maybe I was wearing a hat. Maybe you change the color of my shirt to white. Maybe you change my jacket to a denim jacket, and maybe you put a tattoo on my face. Just assuming, right? You've transformed it. But if you just paint it exactly the way it is, you cannot say because one was a picture and one was a painting, then it's transformed it just by it being a painting. No. For you to transform it, it has to be radically different. Okay, that's fine. Yeah, so we also talked about Andy Warhol anniversary. Next one, please. Next slide. Yeah, go back, please. Yes, so fair use. Fair use is very important. And I also like to share the spirit behind fair use. So the fair use doctrine, right, is majorly to protect the public in the sense that the fact that I take a photograph or it's copyright, I should be able to use it freely. Right? For instance, in this my slides, right, I've used some pictures. I used the picture of the jellyfish, I've used the picture of LeBron James, yeah. I've used a couple of pictures in this slide. Can the artist using those pictures sue me for copyright infringement? The truth of the answer is no, because there are some exceptions that fall under the fair use doctrine, right? One is educational purposes. So I'm publishing this and sharing this with you guys just for educational purposes. I'm just using it to teach us about copyright law. So that's an exception in itself. So the law recognizes, right, that the fact that something is copyright protected doesn't mean people cannot use it at all. But there are guidelines on how they can use it, and that's where fair use comes, right? So fair use basically protects the public from the opportunity to use pictures without them saying they've infringed on copyright of a person, right? Because not every use is an infringement. That's also what I mean. That's why I also said during the course of this discussion that infringement is discussed on a case-by-case basis, right? So you have to examine each particular case to know if criminal as a whole. So if you're going to take away two things, right, from what we're discussing today, as regards photography, visual art, copyright protection, what I want you to take away is transformative use and fair use. Transformative use and fair use. I'll say it again. Transformative use and fair use. They are very important because in the future, if you have to act on behalf of a client, or you might even be a judge in the future, right? And you have to state on an issue that has to do with transparency use of an image, and the fair use of an image. Let these principles stay with you, let these principles guide you all through. Yeah, next slide. So yeah, in conclusion, the work copied without distinguishable variation from the prior work, even though the duplication may require special skill, training skills, and independent judgment on the part of the copyright is not in itself sufficient. This is what I said earlier. The fact that one is a picture, then the artist drew an artwork from the picture. The artist cannot claim it is not copy, that they are not infringing on the copyright simply because one is an artwork. No. Right? It has to be totally transformative in its use. So next slide. Great. So that is the end of my presentation. Thank you so very much for listening. And once again, I apologize that I said I was going to leave. I want to medically have some presentation. It's just because I'm trying to get back to the event that's currently happening right now, which is the Africa Creative Market and the Global Legal Creative Summit. I spoke earlier in the day. I was on a panel earlier in the afternoon, and the event has continued until this evening. There was a session for 6 p.m. I'm about to join in now, but I just felt I owed it to you because I already prepared my slides, I just felt I needed to come and talk to you guys for a bit. Excuse me. Then yeah, so that's it. Thank you so very much for listening. I appreciate your time. I don't know if anybody has questions. If you have a question or two, you can use up so that I can answer them quietly. Thank you very much.
Thank you so much, Mr.
Good evening, sir.
All right, so please, who is asking? Okay, please go ahead and ask your question.
Yeah, good evening.
Yes, good evening.
Like now, if you said a photographer owns the copyright to a picture and he can use it anyhow he likes. So like just like that celebrity that they used, that he snapped his picture and then he posted it, then he sued him for snapping his picture. So like let's say all those now recently that celebrities try like having their own trademark, like their face, like you can't use their face to advertise. And also like if a photographer snaps a celebrity and then use it for his to monetize for himself, so is that not like infringing on someone else's copyright or infringing on someone else's rights? Because I don't think someone's rights should someone's rights, and I don't know how to put it, like they should not conflict.
Okay,
so let's say my face is my, if I assume that my face is my own trademark now, so if someone is snapping me and then using my pictures everywhere and I don't like it, can't I ask the person to take it down?
So to just give you a classic example, my sister experienced this recently and she called me about it, and this is what I told her. It was her birthday. She went for a birthday shoot at a photography studio. She had the shoot, she used it for her birthday, it was on her social and everywhere. She was now walking past or driving past the photographer studio like months later. She now realized that the guy had already took a picture on his billboard. Funny enough, she was not the one that saw it. It was one of our cousins, that saw a picture on the guy's billboard. And I took a picture and sent it to her. I said, look, this guy is using a picture for adverts. And she called me and she asked me if she could sue the person. And I said, well, the guy owns the photograph, sadly. So that's why it's good for people to be informed. So this is what I do personally, right? When I go to the photography studio, like I have a daughter, right? And there was one time when she just had my birthday, and we went to a photographer to have a shoot. And while the photographer was having the shoot, I called the photographer and I said, look, one, the copyright on this picture that you're taking, you're going to transfer them to me. I told him outright that you're going to transfer them to me. Secondly, I don't ever want to see my daughter's pictures on your marketing material. I don't want to see it on a billboard. I don't want to see it anywhere, right? I'm not giving you that right to do it. And he and I had that understanding. Right? So it's important that you have that understanding. But now let me tell you something else. Like I said earlier, deciding infringement and copyright law is on a case by case basis. So, first instance, he used your picture, but what did he even use it? How did he use it? You know, those are the questions that need to be asked, and those are the things that need to be evaluated. But you cannot just say because it's your picture, right? Then um, the person does not have the right to use it, you know? Especially if you're in a public place. So I am at landmark, right? This is where the event is happening. A couple of people here, a couple of people in the hall, outside the hall, everywhere. Assuming I take a picture and someone is randomly in the picture and I post it on my socials, the person cannot come and sue me. One, I took the pictures. Two, you were in a public place. So I just took a picture of myself and maybe you just happened to be in the background. So you cannot really sue me. And if you try to sue me, I'm going to win the case in court. You know. So yeah, these are the things I like you to know. These are the things I like you to pay attention to. But there's something I also want you to know. In the film and media space, right? And I'll give you an example. I'll give you an example. Um, Imagine when you are partnering with something like Netflix, right? When you submit a movie to Netflix and you want them to stream it, Netflix has to be extra careful. You know why? Because Netflix has a lot of money. People will see them and see it back and say, ah, this people have money, let's sue them. So Netflix wants to be extra careful. So they ensure that the producers, the directors of that movie, you have a license for everything. If they waka pass in the film, you have to get a sign off from that person. That's why in some films now, they don't actually allow anybody to just waka pass. It was back in the day that they used to do that. Just someone that just features by coincidence in the background of the picture. Now, they tell you to track that person down, or as that thing happens, they'll actually tell you to reshoot that that scene and cut that person out and reshoot it with that person. Or they tell you to ensure that you have a silence from that person or you're not going to sue. Because when that person is at home and he sees his face on Netflix, it is not the producer that wants to go to first. You just call their lawyer. Ah, I sent my face on Netflix. Let's sue Netflix. You get so Netflix try to be careful. They are even so detailed that even the houses that the camera finds over, right, in the movie, you have to get a license from those people. Right? That okay, they sign off that they're not going to sue and give them the license. So organizations like that are extra careful because it is one thing to be sued, it is another thing to win in court. But after they sue you, before you win, you are going to get a lawyer, right? You are going to pay that lawyer, right? When you now eventually win in court, it is fine, but it has cost you some money as a company. It cost you some money. You paid the legal fees that you used to engage the lawyers to win in court. So they don't want to even get to that point whether they're spending money or not. They don't even, yes, they know that they know what the law is, but they just don't want to get to that point. That's why they say from the very beginning, just get license from everybody. Yeah.
All right, thank you very much, sir. We really do appreciate your time, and we thank you for helping us run through those questions, or that question in particular. Thank you so much. I think, sir, we'll be allowing you to take your leave. We are happy that you at least had time to share with us your thoughts and also your presentation. We are sincerely really grateful. Thank you very much.
I am most grateful. Thank you so
All right.
much. I really appreciate it. Thank you so much.
Yeah, no problem, sir. You're welcome, sir.
All right.
Sorry. All right. So moving on, we want to move on with what we have for today. But before we do that, right, please, we would like to take a quick screenshot of of the class before we move to our next mentor, right? The lighting in my own environment is becoming duller and duller. So please, I'll just like for us to just take a quick screenshot and then we can move on with the rest of the class. Please, can you kindly turn on your videos? Thank you, Kwan. Thank you, Catherine. Please, can we have more people turn on their videos so that we can take a quick screenshots and then we can move on? All right, thank you, Blessing. Thank you, Odafe. Sorry if I didn't pronounce your name very well. Thank you, Hilary. Yes, you guys can smile too. Thank you. All right. Okay, just one more. All right, yeah, we are done with that. So moving on, two of our mentors are on call. I can see Miss Omotayo. It's nice having you back in our mentorship program. I'm so happy we are so happy to have you on call. I can also see Mr. Shei is here with us. Thank you so much, sir. Mr. Shei has been with us in one of our subsequent classes. So before we go to Mr. Shea, I would just want to give the floor to Ms. Omotayo, saying that this is the first time she's been with us in this particular quarter. So Ms. Omotayo, the floor is yours for your presentation. We'd like to hear from you. What's your share and what's your take on the topic for today, photography and visual arts?
Okay. Good evening, everyone.
Yes, good evening, ma.
I hope you can hear me. Yes. Okay.
Yes, we can hear you.
Okay, excellent. Thank you very much. Good evening. I'm trying to remember your name. I beg your pardon. Okay. Sorry. Good evening, everybody. Good evening, Shei. Shei is on ground. How are you all doing? So I think Adedumade has said quite a lot of things, and I would not like to waste your time. I'd just like to go straight to the practical aspects of these. First of all, as a way of recap, copyright to me is simply the right to your own original creative and artistic work. Let's say put simply, right? So we all know already from what the previous or the first speaker mentioned that the original copyright in a photograph or in a visual work is actually in the creator. So one key thing to note is that you take the picture, you do the art, you are the owner. But there's always that exception, of course. But if there's a contrary contract stating otherwise, then whatever that contract says overrides this original law that states that copyright in the photograph belongs to the owner. So that's a way of recap for the introductory aspect, right? So I would like to just move straight to strategies for protection of your copyright in photograph, in works of photograph and visual works. And the reason why I'm going to these strategies because oftentimes I believe we're more lawyers here. I don't know if there are creatives or creators here right now, but oftentimes as lawyers, we just want to stick to, even myself, you want to just stick to the legal aspect. But there are times you can actually think of the practical aspect as if you are a creative. So one of the basic things you can do is to protect your own work. So I'm saying your own work as if I'm speaking to an artist right now. So if you're a lawyer speaking to your own artist, the first thing you're thinking of is, I need to protect this creative work of mine. And beyond or before going to legal protection, right, I would like to say basic things like watermarking. Of course, there are tools to erase watermarking, right? But as basic as watermarking your creative work, such that when somebody else sees this work after, they can say, oh, this work belongs to so person, even if it's something very, very tiny, right? As a photographer or as a sculpture artist whatever kind of artist you are, it's okay to just basically watermark your own work. And beyond that, you can go to there's this site. It's I would like to see if you can. Okay, I didn't provide my slide. Oh, apologies, please. Google Reverse, yes. So you can just upload a picture as an artist. I don't know if anyone knows about the Google Reverse, you can kindly notify. We can practicalize it right here, right now. How that works. Does anybody know about that? Is everybody hearing me?
Yes, ma'am, we can hear you.
Does
just
anyone
speak
know
to-
about the Google Reverse, image reverse? No one? Okay, so this is how it works, right? You upload a picture, because there are times that people use other people's photographs, other people's pictures, without the consent of the photographer, who is the real owner. So your own job as a photographer, or you, lawyer, speaking to your photographer, who's your client, is to inform them that they have the primary duty to police their work. No one will do that for you. So yes, you have copyright in your work, but it's your duty to police your work. That's go after your work to be sure that no one is infringing on your own copyright, especially in this age and time where, in the digital age, where you can literally lift anything online and then post online and state that it's yours. So with this technology of the Google image reverse, if you just if a photographer uploads their work on the site, if you can't check it now, you can check it out later. It's very, very direct, right? You can see the true owner of a real picture. So that's one technique to use as a photographer to police your work. Now, this is practical I'm speaking about. And then for sculpture artists, there are times you go to art galleries, right? There are some smaller art galleries here in Nigeria that some people just put a collection of artworks without actually tracing it or getting license from the real original creator. So one thing you can also do is to embed maybe copyright notices on your work. So now that's, by the way, that's a strategy, or those are strategies, practical strategies. But the take home from here is that as a creative, whether as a photographer or a visual artist, it is your own primary duty to police your work so that you can look out for infringement and then decide to sue. Now, I would like to deviate a bit to go to this strategy, which is more like a conflict between copyright and image rights. And the reason why I'm jumping to this is because of a question someone asked, the last question that was asked. I would like to address that because that's part of what I planned to speak about. You mentioned if a celebrity sees their photo somewhere, they should have a right to say, why are you using my photo? Now, this is where there's a thin line between copyright and image rights. Oftentimes, when we're speaking about copyright, we use the word image, which is okay because we can use image as photography, but the image of the individual is like you take a screenshot of this now. Let's assume this is a photograph you take, right? You as the photographer who took the entire photograph itself, which is an intangible property, you have copyright in that. But myself, Omotayo, as the individual, which that's just like the word you used, Adejumade said the element when I was talking about bird. Me, Omotayo, as the individual in the photograph, regardless of the fact that I am not a celebrity, right? I have image rights in that photograph. So image rights is a fundamental human right. It's a privacy right. So this is where your question, person that asked that question, this is where this might address or help your question. The photographer has the right in that photo, but the individual, the celebrity or the individual in that photo has image rights. And that means you can't use my picture in such a manner that I would ordinarily not use it. For instance, you're promoting pornography or you're promoting something really indecent, which I'm not known for, or the celebrity in quote is not known for. That's you infringing on their own image rights. And even beyond, even not as brave, as pornography, even not something great. The fact that I am an individual, I am a person, so it's a right in personal, if I can say that, so it's a personal right, aside your own right as a photographer. So these are two rights staying side by side. But of course, if you take a picture in just a public place also, if you take a picture in just a public place, right? Like the paparazzi, I like to give the example of Rihanna and one of those paparazzi moments. A picture of her was taken, and then Rihanna used the picture on her Instagram, if I can remember. I can't really remember, such a long time ago. And the particular photographer came after Rihanna. She had to take it down. So this is because the photograph, it is Rihanna, it's her picture, it's her image. He has copyright in that particular photo. He took that photo. It was even, I think it was even watermarked at the time. Now let's reverse back to image rights. Sometime in 2018 or thereabout, right? I handled a case for Jumia. It was actually Jumia and RMD, and it's this image rights issue. It was, I don't know, it was quite it was quite all over at the time. Jumia had, I don't know, somehow had the photographs of RMD on their website, promoting pictures of outfits he wore, promoting pictures of outfits for commercial purposes. Of course, you know what Jumia is all about. Now, Jumia didn't even take, they're not the owners of the photograph, of course. But the reason why RMD could sue is because his image was being used without his permission, without his consent, for commercial purposes. So this has nothing to do with your copyright and photograph. This has to do with the individual. Aside the fact that he was a celebrity, right? Okay, so aside the fact that he's a celebrity, any other random individual could actually do that, but it would, it is much more common with celebrities. So that's about image rights and copyright. So I would like to take you back to the exceptions, because this is very, very important. Fair use is a very, very common exception, but I think practically in real life, right? The way to draw the line, this is my own personal opinion. I do not think any particular judiciary has really established a proper line for determining fair use. Yes, I know theoretically we understand that you can't use someone's work in a particular manner if you're using it for educational purposes. Yeah, if you're using it on the news, it's okay. If you're using it for research purposes, but there are times that this fair use actually goes in practice. You can't really draw the line. There are times that people use people's hard work and rely on that fair use. Whereas you are saying glaringly that this is being beneficial to this person. They might come up with the defense that this is not for commercial purposes. But to me, when you're using someone's creative work and it's beneficial to you in one way or the other, even when it doesn't fall under educational purposes, you can't rely on the fact that it is not for commercial purpose. This is my own personal opinion. I stand to be corrected, of course. The fact that you're benefiting from that particular work, you can't rely on fair use. So I just think generally as a creative, contracts would really, really help. When you have whatever it is, I believe that for contracts, of course, aside for illegal purposes, right? For contracts, whatever you want, I want this, you want that. Just like Adedumade mentioned earlier, he said when his daughter was supposed to take a photo shoot, he had to tell the photographer that this copyright in this belongs to me. It's as simple as that. So if everyone is aware, one person tells this person, like the way we are doing now, you're aware, and I believe you're going to spread the word across to every other person you come across. Once you have a simple contract, and contracts, yes, it's good to have a lawyer to draft a contract for you, but as basic as what he said, put it in writing. The copyright in all of this belongs to me because I know ordinarily it should have been for you, but I want it for me. I do not want you to publicize my photographs. I do not want you to use this for, even aside from commercial, I don't want you to use this for any purpose whatsoever. And it's signed. So this is where commissioning and work for hire can come in. So there are times that, like in film and media, right? In film and in the film business, what we do most times is that when you sign a contract with maybe a very, very popular actor or a very, very popular maybe a video vixen, and you just commission them to do a particular job for you, you have to state it clearly that you own every copyright in this work, and that includes their photo. You know, sometimes there are times that we take BTS photos, BTS shoots. You have to be very express that as so long as this particular job is concerned, every image, likeness, picture, photograph, use of this belongs to the production company or the producer, as the case may be. These are clauses that are always in such contracts. So lastly, I would like to also address the images of animals. Let's say images, okay, obvious things that, especially for visual artists, images of maybe a dog, a snake, a monkey, of animals, of course, not like human, because it's only humans that have that image, right? For animals and other natural things, when you draw them or when you take photos of them, you do not have rights. Of course, the animals don't have rights, so no one can claim rights to those images. That's the elements themselves. Aside human beings, we human beings are the only ones that can actually lay claims to the image, right? So animals and plants do not actually have image, right? So as an artist, a visual artist or a photographer, when you take photos of such, the entire photograph itself, that's the intangible rights, of course, belongs to you. Copyright in the entire photograph, but you can't lay claim to that rat or snake or whatever animal or plants you found there. Lastly, I'll just, by way of conclusion, I'll just like to, what I need you to take home, which is very important, is that as a creative, regardless of where you think you are or where you think, even if you think you are up and coming right now, your intellectual property right is like, it's literally like all that you have that you can hold on to for years, forever and ever. So you need to do all of what you can to protect it, to own that right. Don't leave your intellectual property rights just hanging right there for people to just come and infringe upon. Do not wait until there's an infringement before you think you can protect your works. It's very, very important to protect your works, and do so by doing basic things like I've mentioned. And then contracts, when you are hired to do a particular job, it depends on what you want. If you want them to have all of the ownership, of course, you can transfer. If you want to own your work, it's yours already. So basic contracts, have a lawyer review contract. There are contracts that would definitely want to take away your copyright in that work. So of course, you know the fact that the original works, the copyright in the original works belong to you. But imagine you signing a contract without reviewing it, and then you've transferred all of that right, all of those rights in that work to someone else. And then when there's issue in the future, you think, oh, they already mentioned that automatically the copyright belongs to me. So it's quite simple and dicey alongside. You have to just be watchful at each point in time. So if I'm speaking to lawyers, entertainment lawyers, or intellectual property lawyers here, all you need to know is you need to just know your basic intellectual property rights in all of these creative works. And you need to know how to assign rights in contracts. whoever your client is, you need to look out for their own rights in that particular contract. Be careful not to transfer or assign all of their rights or lose their rights by simple words or technical words that we use in contract. Just have to be careful. A line of transfer, a clause can actually destroy an entire creative's work for years. I hope this makes sense to you all. And that'll be all, so I can let the next speaker speak. I hope if you have questions, of course, you can roll them in. Thank you.
Thank you very much.
Good afternoon. Good evening, ma.
All right, so please go ahead with your question.
Yeah, it's not really a question. I just want to ask back because she was answering my question that I had for the other mentor. So I think my network got cut off because I didn't really hear. And I think she said something about the picture, if it's being used for commercial purpose, that the owner of the picture can actually tell the photographer that is using it, like maybe to take it down when it's publicizing it for commercial purpose
Not just
and monetizing it.
Okay, I used the instance of RMD. I used celebrity. So when you can prove that there's certain benefits attached to the use of your photograph, like a celebrity can see that you are fronting their picture as if they are your brand ambassador. You don't necessarily have to write RMD is my brand ambassador, but you put RMD in a two-piece material and you're putting it on your, let's say, MDL's closet. Let's assume there's a boutique called MDL's closet on Instagram, and you're saying RMD, putting up the shirts and trouser. RMD can actually come to say, you know what, you have to take this down because you are using my image for commercial purposes. So that's image right. That's his own image right. So for image rights, it's not just for celebrities, even for individuals. You have to prove that you have lost certain things, some benefits accrue to that person by virtue of using your own image. So if you see someone using your image for commercial purposes and you believe that maybe you're an influencer, it might be an influencer, you believe that they are getting some certain kind of benefits by the use of your image, or they're using your image for illicit purposes, for illegal purposes, or for purposes that you would ordinarily not be found. Like no one will ever see my picture on a pornographic film business. Even though I'm a film lawyer, you won't see me promote such. So imagine I see my picture, even though I didn't take the picture, on such posters. I can sue them to take it down, coming under my own right of privacy as an individual. Or even my child, if just like you said, this child's photograph that was taken, right? If you're using my child's image for purposes that I would ordinarily not, allow, I can actually sue you because you're infringing on that child's image right. So I want to come under copyright because I do not own copyright in that photograph. I'm talking about the individual. Recall when he was speaking, he also mentioned something about when you see a bird in the air, right? And you take a picture of the bird in the air, you can claim copyright in that photograph itself, but you can't claim copyright in the bird because bird is a natural, it's an animal. Nobody can claim ownership of the bird. I hope the person is still listening to me. So now, in this instance,
yes,
replace bird with individual, with a human being, right? As an individual, you have the right to sue if your image is being used or your likeness is portrayed in a manner that you would ordinarily not be found in. So you have to be able to prove it. And oftentimes, individuals like us might find it difficult to prove, but it's easier to prove by celebrities. It's much more easier to prove for celebrities. I hope that answered your question.
Yes, ma. Thank you very much, ma.
All right.
All right. Thank you so much, Ms. Omotayo. And thank you to
I can send you a link much later. I'll send I think it's Sophie on this live.
She had to take her leave, but she'll be rejoining us.
I can send a link to explain image rights and copyrights in photographs. But I did a video on that some years ago. I believe it's still the same thing if you want to get more context.
All right, thank you very much, Ma. So we'll be taking questions. We have a whole session for question and answers. So please, those with questions, you can kindly just drop your questions or even send them to the chat box, right? And then we'll reserve them for that period so that we don't get caught up answering questions while we have other parts to address in this particular class. So thank you so much to Ms. Omotayo. Thank you to Mr. Adedumadi. Okay, Mr. Oluwaseyi has requested that he will be taking his presentation after the mentees are done presenting. So moving on, we'll be taking presentation from the two groups. So group one, please, if you're ready, you have 7 minutes for your presentation. You can share your slides so that we can move on with class. So please, you can start your presentation. We'll be moving on to Mr. Sheyi after we are done with presentation. And while group one is making presentation, group two, please also kindly get ready, ensure that your presenter is on call, and then also that your slides are available. So
Okay,
group
good
presenter,
evening.
please, you can introduce yourself and continue with the presentation.
Good evening, everyone. Please confirm if you can hear me.
Yes, good evening. We can hear you, Chisom.
Okay, so my name is Chisom Iboka. I'll be presenting for group one on the topic protection and monetization of photography and visual artwork. Our last two speakers have said almost everything on photography and copyright. So we know that these days photography is a lucrative business. You can choose to do still life photography, nature, human beings, abstract photography, whatever. And it's an avenue for people to make money. And as they rightly said, there is copyright in photography, and the copyright lies with the person who took the photographs, that's the photographer himself. And the new Copyright Act said, if you read the section, it will say, unless otherwise agreed by parties. So you as a person can commission a photographer to take your pictures, and then you tell him to, then you have an agreement with him that you will own the copyright. So he will not use it for any of that thing. But in the absence of that, the photographer owns the copyright to the image he's taking. So I would just like to draw our attention back a little to what Mrs. Omotayo said on the thin line between copyright in photography and then image rights. So as she said, as an individual, I own image rights, but as a photographer, I own the copyright, meaning if I can take your pictures as a photographer and display it in my studio for people to see my work, and they can use it to judge whether they want to employ me or not. I can also have a catalog and exhibit in a photography exhibition as as a photographer and say I can even sell it. But there is a limitation to what I can do with your pictures. For instance, Mrs. Omotayo, I heard when you were trying to draw, make an example with Rihanna, and I think I came across that case recently, and the celebrity who had that issue either early this year or late last year was Miley Cyrus. So a photographer took her pictures unawares and posted it on his website. She saw the picture, she liked it, and she took it and put it up on Instagram. And then he sued her for it because it is copyright. And of course, she took it down. Then in the case of Rihanna, so there is a case, Fenty against Arcadia. Arcadia is the parent company of this fashion house, Topshop. So they took an image that has a very striking resemblance to Rihanna and printed it on their t-shirts and started selling. So Rihanna sued, although at first the trial court was like that the English court, because it happened in UK, that the English court does not recognize uh, image rights as at then. However, Rihanna was able to prove that because the case went on appeal. She was able to prove that even though she's a musician, she's also into fashion, and that people are buying this shirt because they feel like Rihanna is associated with it, and she's not. So they are profiting off her own goodwill, and the court agreed with her and ruled in her favor and awarded damage. Lastly, the last example now on image rights that is also linked to our right to privacy. So I can't remember the name of the case. I just read it in the website. I didn't know that it will come in handy. It's a Kenyan case where a dispatch rider went to an estate. It was a new estate, and while he was waiting for the customer to come and take delivery, a, a photographer that was taking pictures of houses in the estate for their brochure saw them and asked the riders to pose. So he posed, smiling, and they took his picture. And they didn't tell him what it was going to be used for. So they ended up using that image to advertise and say, you too can own a house. So it was as if he bought a house. So his people started calling him, oh, you bought house, did not tell us, blah, 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 blah. So he went to court to contest that they violated his image rights and used it without his consent, and he won that case. So it's very important, even as a photographer, to always take the consent of your customers or individuals you snap when you want to use uh, their pictures for a purpose which you did not agree with them on. So moving on, there are various ways you can protect your works as a photographer. You know that we are talking slide 6, please. So we are talking about monetization of photography and visual artwork. Please note that as so I'm talking about photographs. The same applies to artworks. So whoever draws the art is the owner. And if you are commissioning an artwork, there has to be an express agreement between you and the artist on the ownership. Because I can do an artwork, a landscape artwork for you, and still want to exhibit it in an art show that this is my work so that I could get more customers. So if you want to protect your work as a photographer, you can watermark it, you can add a digital barcode, then include the copyright notices and metadata, or use low resolution images. Also, on your website, you can have terms and conditions for the use of your work. And like Mrs. Omotayo said, doing a reverse image search on Google and also having your clients sign. In fact, in this age and time, I've heard, I think some time ago, I saw some people arguing on my WhatsApp about the photographers asking customers to sign that they own the copyright. One of them was actually ranting that is not my picture. That how can a photographer tell me to do this? As much as I tried to educate them, I didn't, because they were adamant, I didn't push it. But then it's important that we all know this, and it's also important for photographers to know their rights, because sometimes you can scare them off and they will just let it go because they don't know that they have a right in their photography. So I would like to add that I think the US law is more advanced in terms of protecting copyright. So in their Digital Millennium Copyright Act, if you see your work on any social media platform and it was posted without your consent, aside notifying that platform, because you know that most, like Facebook, Instagram, Twitter, you can actually report a work for copyright infringement, and that is a requirement under the Digital Millennium Copyright Act of the USA. And you can even take it a step further, aside, because some people can be adamant. You notify them that this is a copyright infringement, they still go ahead to they will refuse to remove it because what can you? So you can actually come under this DMCA and claim rights and have them remove it, and you can also claim damage. Sorry, I'm rushing through it because we have only 7 minutes. So I'm going to go right on to because I think we've talked so much about image rights, photography, and copyright. So I'll just talk about blockchain technology for art authentication. So I don't know about others, but the first time I heard about the blockchain NFTs was 2020 at the height of lockdown, when everybody was at home, and you know that all of us resorted to online. So these days people can use you know, when NFT started raining, people were now minting digital artworks and photographs. Even myself, I tried to do, and even though I didn't know how to use it, I was just asking my friends. There was one picture I took where I was wearing traditional outfits. I was telling them that this thing can pass as an artwork. Let's mint it and sell. We will share the money, things like that. So the good thing, what I like about minting art or pictures through NFTs is the ownership it gives you as the creator. So even when there is a kind of authentication it gives to the work, so that even when you sell it, you retain that ownership. And even if they buy and resell, there's always like a digital trace where it repeats, it keeps telling you as you are buying an artwork, you are made to know the origin. It keeps telling you that this work was originally created by this person. And okay, yes, you can buy, but there is a limit to what you can do with it. And you cannot, in turn, start claiming ownership just because you have bought it. You can buy it and use, but you cannot claim ownership. So that is what blockchain technology does for us in terms of art authentication. These days, you can also use blockchain uh, to certify artworks, both physical and digital artwork. So now, people, if you do a physical artwork, you can actually, you know, do a virtual version or do a blockchain authentication on it, so that when people come online and see this thing, their blockchain technology will show the owner and the origination of that work. So some of the advantages of using blockchain for art authentication is the proof of records, like I said earlier, where no matter how many people that have bought it, there is a record somewhere on who the original person is. It also gives us transparency as it creates a history and authenticity of the artwork. And then there's also, I know that when the NFTs came, some of the um, some of the appeal that the business of selling and making those transactions, and you don't have to go anywhere. So it just makes your this thing secure and automated. And as a creator, you can actually transfer your rights to another person, and you just initiate the process through smart contracts, and then they can change ownership as long as you and this person come to an agreement. Some of the disadvantages and the challenges of blockchain technology for art authentication is adoption and integration. As much as we, the new age people, I will not say Gen Z because I know some millennials too are tapping into it, but as much as we, the new age people, are trying to embrace these new technologies, there are still people amongst us that have reservations about it. So it's difficult to sell blockchain to them or tell them that NFTs is good. In fact, if you notice, most literary competitions, there is a debate now where they now try to sieve submissions to know which one was done by AI. They would rather something you wrote by yourself and the one you got AI assistance on. There is the way they are accepted is different. So it's the same thing with artworks and pictures too. They try to sift through the one that was created digitally and the one that was created traditionally. So people still lay more emphasis on the traditional artwork. So it's still gaining acceptance. And I think maybe with time and continuous usage, we may be able to convince some people to buy into it. Also, there are privacy concerns. As much as we say that blockchain is a decentralized network, it is still it's not foolproof. So it still has the same issues we are having with our regular transactions. There can still be infringements. I mean, blockchain was created by a person. So somebody else who is smarter or more cunning, not necessarily smarter, you can be more inventive and find a way to bypass some of these technologies. So people can still bypass and steal other people's work and claim ownership. Or maybe me, I don't know how to use blockchain. I'm just a traditional artist. And then somebody who is smarter can actually steal my work and then post it online and mint it as an NFT as their own. And before I find out what is going on, the person has gone far, made a lot of money. And if the person is outside the country, how do I start getting this person to pay me for to pay me damages? So those are the issues. And finally, regulatory issues. So in Dubai, they recently made a law that recognized copyright ownership in AIs. So they said a robot created something, and they said that the robot is they granted a copyright ownership on the robot itself, so not in a human being. So it's a challenge for us in modern times, because how do we draw the line between human ownership and AI ownership? So if I create an artwork with the help of AI, do I own the rights or does AI own it? So those are the issues that I feel like things that we should consider as we move forward in trying to regularize usage of blockchain technology for art authentication. So that is the summary of my presentation. Thank you, everyone.
Thank you so much, Chisom, for your well presented for your presentation that you hosted so well. My sincere appreciation to both you and to your group members for putting that slide together and ensuring that you guys had a wonderful presentation in class. So moving on, we'll be having presentation for group 2. Please, if you can make it as quick as possible, 7 minutes, we'll really appreciate, so that we can get feedbacks from our mentors and then we can go to questions and answers. So please, can we have the group presenter for group 2?
All right, good evening, everyone.
Yes, good evening, Mr. Peter.
Sure. I want you that you can all hear me. So I'll be presenting for group 2, and I'll be talking about licensing and royalty models, legal challenges in online platforms and cultural heritage preservation and digital reproduction. So basically, we all know that the digital technology has really affected the entertainment space, which photography and visual arts are not exception, from creation to dissemination and consumption of photography and visual art. We all understand that virtually traditional way of creating photography has really evolved, and also dissemination has evolved as well. We've gone That's the time where we do majorly have hard copies for photography and visual art. Now we can all have access to photography and visual art through our digital mobile phone and online platform as well. So I don't know who to share for our screen to share.
Don't worry, I'm
So
putting up your slides now.
All right, thank you very much. So please kindly go to photography and visual artworks. No, yes, the third slide. Thank you very much. No, the fourth slide. So, what is photography? Photography is the art and science of capturing image using light-sensitive materials, cameras, phones, and taking pictures for different purposes. Some people take pictures for adventure purpose and for storytelling as well. And why some people also make use of visual art to communicate their feelings. Some people also make use of visual art to tell stories. You can have a visual art whereby you have a moon and a dark paint, which may tell us about maybe the sad mood, communicate the sad mood and all that. So I believe you understand the visual art and the photography. So what is intellectual property? Intellectual property is basically an intangible property or same property whereby you own ownership to your artwork or photography, where you can control your artwork, where you have the rights for exploitation and also to copyright to protect your intellectual property. Basically, it's the ownership to your creation of work. And one of the major reasons why you have to protect your work is to prevent your work from infringement and also commercialization of your work. That's the business part of photography and visual art. Because it is very important why you creating your work. It is very important you also make a profit from your work and by using it for your profit and all that. So licensing and royalty models. Licensing refers to granting permission to others to use a creator's work. It's simply the authority you give. You authorize the use of your work. And one of the fulcrum for licensing is contractual agreement. It is important to note that when you license your work, you must have a contractual agreement with whatsoever that will make use of your work by stating the specific terms that the work will be used for. So this contractual agreement will guide whoever you are licensing your work to. And royalty models determine how creators are compensated when their work is being used. The payment they receive while making use of their work. We have three types of licensing: photography and visual. That's exclusive licensing, non-exclusive license, creative common license. So exclusive license simply the right to use a virtual work for a specific period with the artist or photographer retaining the ownership. So this basically means that when you license out your work, you still retain the ownership of the work. The user can only make use of the work for specific purposes as stated in the contractual agreement. The licensee does not own the right or does not own the ownership to the work. Why not exclusive licensing means that when you license your work out, you can definitely also give this same work to other person, which means if as a photographer, I'm licensing my work out, I can as well share the same work to other person. The user does not own an exclusive license for the usage of such art. And Creative Commons licensing, artists can share their work freely with some conditions. It's often used for digital content and it allows creators to specify the level of control over their work being used. So basically, you can have an online platform whereby you release your work freely and people can have access to your work. But however, certain conditions will be stated with the usage of your work in order not to infringe on your work in terms of defamation or making use of such work for illegal purposes. So royalty models for visual art, we have per use, whereby artists are paid each time their work is used or downloaded. Someone makes use of, maybe there are platforms that accept visual artwork or photographers' work. You can go to those platforms, whereby when you download that artwork or photographer's work, such per work, the photographer will be paid as you download it. Subscription model, whereby you subscribe and you go online to make use of such work online where you already subscribed to the platform. And revenue sharing, for example, there are some people that are into digital art, they are digital artists. Maybe I'm doing a cover, like for a song. Let me use music, for example. Maybe a friend of mine wants to release an album, and I'm doing a visual artwork for such song. You can have and we can have an agreement that, okay, I'm not going to get paid now, but in terms of streams that you get, or probably royalties you get for that song, it all boils down on contractual agreement. I will get a percentage from that streaming. So you might not get paid at that point in time. So maybe the percentage which the artwork generated through the music, you can also get your revenue through that. So licensing and royalty challenges in Nigeria, informal transaction. Like I said, one of the fulcrum of licensing is contractual agreement, whereby you are giving out your work, or probably you contracted on a particular work and you don't have an express agreement or legal agreement between you and the other parties. It might really affect the usage of such work. And lack of awareness. Many of these photographers or visual artists or digital artists are not aware of their rights. They have no idea that they own a certain rights to some of their works, whereby their work is being exploited and they have no idea on how they can generate revenues from this, from their works. And enforcement issues, that's one of the problem challenges we have in Nigeria, whereby there's a week of legal enforcement. Maybe the photographer does not have enough funds to get the service of a legal advisor to pursue such case. Also, copyright infringement, because intellectual property rights are intangible and they are more susceptible to theft and illegal use. Legal challenges on online platform. We've talked about fair use and fair dealing. It happens to be one of the legal challenges on how you can trace those who make use of your work. And fair use and fair dealing is basically, maybe you are using a work and you are not monetizing it. So that person may really have rights to that to make use of such work. Digital rights management is not really really enforceable. You don't really have that stand, because I guess they don't have their stand, and that is not being entrenched in Copyright Act of 2004. So copyright infringement, many artwork are used without permission on digital platform. That's another thing, whereby maybe on Instagram, on Facebook, TikTok, some of these art are used without permission on digital platforms. They make use of your work without your permission. Piracy, unauthorized download and sharing of virtual art. There are some platforms that they download visual art and photography without your permission, and they also share this work without your permission and your authority. Nigeria legal framework for photography and visual art. We have copyright of 2004, which was stated by the first speaker, Section 108 of the Copyright Act and protect the artistic work. We also have Cybercrimes Act of 2015. This act addresses some online improvement issue and note this regulates intellectual property and transfer but faces enforcement challenges. We are here to have agency that can enforce this particular intellectual property. So enforcement challenges, we have jurisdictional issue. It is difficult to take action when online platforms are hosted abroad. Some of these platforms whereby the artwork or the photographer's work is being infringed upon, they are abroad-based platform. So it is very difficult to even have maybe we have Nigeria communication commission that is in charge of regulating intellectual property. You may really have difficulties in writing to some of these online platforms to trace or track individuals that infringe upon such rights. So it's very difficult to track and trace. Legal awareness. Many artists don't know their rights on how to seek legal remedies. They end up forfeiting their rights due to ignorance. I've stated that earlier. And also cost of litigation. Majority of these photographer or visual art do not really have the funds to pursue their rights in the court of law. So we have cultural heritage preservation and digital reproduction. Nigeria cultural heritage. This includes traditional like mock sculptures, Benin brushes, Yoruba mats. We have, I think we read about histories whereby some of our cultural sculptures has been transported to overseas and they are being used in their museum there, whereby it's being used for commercial purposes. Digital reproduction. This comprises of digitalization of cultural heritage for global access and monetization. So this particular talking about our traditional heritage and culture. There's a need for us to digitalize some of these things. We should not just keep them in our museum here. We should put them to the digital world by using digital platforms whereby other people from different groups can have access to our cultural heritage because they stand as an artwork as well. So monetizing cultural heritage, modern interpretation, contemporary artists are using traditional motifs in modern works. Ethical consideration, artists need to balance cultural respect with monetization opportunities. So this basically is talking about how we can project our culture in terms of monetizing them. For example, we have like Ogun in Yoruba, we have Shango. These are part of our artistic culture. Whereby erecting and some of these, their images, we should also understand that we portray them in a good manner in terms of monetizing them. So we should just review the bad aspect of it. Community consent. When artists want to engage in traditional or artistic work, you need to also go deep and seek consent from that particular community. Maybe I want to project Ogun, I need to go to that particular community where it's being used to seek their consent before I can put it out to the world. Legal framework for cultural heritage, you have copyright, UNESCO Convention, Benin Brushes case. And I think there was this recent case whereby, I don't know if it's in Brazil, that they said some of our culture brushes will be sent back to Nigeria that they has been used for commercialization. There's something like that. Preservation and commercialization of our artwork. It's very important that true photography, visual artworks is a vital endeavor that not only showcase the nation diverse history. So basically, we must also preserve our culture and in terms of commercializing. So we should not just basically rely on the money aspect of it. We must endeavor to preserve our culture. One of the things is when you are using your art or that photography to tell a story about your culture, you must ensure that you put a well meaningful story about our culture, not just the evil or the bad parts of some of these culture that we know about. In conclusion, the protection and monetization of photography and visual art of Nigeria necessitates a multi-faceted approach that addresses licensing and royalty models, navigate legal challenges on online platforms, prioritize cultural heritage preservation. So I've said that earlier, we must ensure that we preserve our culture in digital reproduction. So when we are putting this in a global space, we must ensure that we protect our culture and also leveraging on technology track online usage, ensure fair royalties will safeguard artists' livelihoods. We have to ensure that we track the usage of this work in the digital space, whereby the artist and photographer can also earn from this their work. Recommendation: we have to develop and enforce comprehensive copyright that is in line with the digital space in terms of copyright, in terms of photography and visual art. We also have to establish a national registry for visual arts works. We have to ensure that we have a national registry for visual art whereby people can take their art works there, and other people from, like, for tourism purpose can come there and also to generate enough economy from the country. Implement blockchain-based license and royalty for tracking. Create online platform for cultural preservation. I've said that earlier. We have to create an online platform that will preserve our culture. That's very important. Also encourage public-private partnership for art development. Public-private partnership. We must not just base it on government alone. You can see the likes of Naked Galleries. That is a private partner. That is a private development for artworks. So we should not just limit it to only look at art gallery. The government should also work with individuals that are really interested in artwork to promote our culture and our heritage. Thank you very much.
All right, thank you very much, Mr. Peter, for your presentation. Well done to you and your group for putting together that presentation. We appreciate the efforts you guys put into the work, and we say well done. So now we'll be moving back to our mentors, right? Starting with Mr. Shea. We sincerely apologize for not taking your presentation earlier on, right? So, sir, we just want to give you the floor so that you can kindly help us run through the topic as well as give us your feedback, and also just generally that, sir. Thank you very much, sir, for joining in.
All right, many thanks, guys. To confirm that you can hear me clearly.
Yes, sir, we can hear you, sir.
Okay, thank you. Good evening, everyone. I appreciate my colleagues who have spoken earlier before me. I did manage to me first, giving us slide presentation, taking us through the ranks of what we're talking about. I appreciate a more kind of very good friends for coming in the next. So I must say that I chose to come at this time so that we don't necessarily give you repeated presentation on the topic, because there was little or nothing that I should add to what Adidumade and Omotayo had given you, that I will not be repeating what they have said. Adidumade gave us through, ran us through the theories, authorities. Then Omotayo took us through the practical steps, to protecting your works and all. So I felt, let me come in at the tail end to respond to the group presentation and then chip in a few things that are not have been mentioned, but I can assure you, even those things have been mentioned in the course of the earlier presentation. Let me also appreciate the group 1 and 2 for their presentation. To start with, even though they had the same topics, it is surprising that their presentation followed different patterns, and that shows the dynamism of research. So even if you have the same topic for 20%, the output of the 20% in a way should not be entirely similar. That is one way to ensure that people went out of their way to carry out research the way they ought to be done. All right. To lean on what Adedmari and Omotayo have said, I've told you earlier that they've done fantastic work. I'm just coming in to share one or two insights as we close tonight. So the first thing I'd like to inform you about is that there's a new Copyright Act of 2022, and I know one of the groups, I think group 2, was referred to the old Act of 2004 in their presentation and of course in their research, and that would have an effect on the work we've done. So one of the things we want to do is to look for the instant law on that subject. Whatever you're saying, you're giving us an informed opinion on that topic. So, the message I'm passing across to you guys is that the Copyright Act they refer to and they use in the research, as in was taken by Venn, but Group 1 used the new act, and that also reflected in the cost of the research. So, prior to the new Copyright Act of 2022, there was little or no protection for digital works, works of photographs on the internet. However, there is a Venn convention that makes provision for protection of digital work and all that. But the issue of domestication had always been around us. But thankfully, Copyright Act 2022 has domesticated largely some of the things we looked at in the Venn convention. So, moving on to Section 10 of the Copyright Act, the new act now, is a go-to section on the subject that we are discussing. Now, one of the things that I mentioned earlier that I love to go back to is who owns copyright in pictures. We got married 5 years ago, and the photographer and I did not sign any agreement as to who owns copyright. And my knowledge of copyright tells me that the photographer owns copyright in those pictures. However, Tayo laid emphasis on image rights, which I was going to say eventually, but thankfully, we started the conversation. The photographer owns copyright in pictures, except you enter an agreement with him or her before the job was consummated. In that way, you pay them off fully for the work, for the service they are rendering, and then you, the person in the photograph, retains copyright. So you must have paid handsomely to arrive at that point. But whether or not you pay to retain copyright in the pictures, in the images, there is image rights which Tayo has laid a heavy weather on, and I wouldn't want to go back to that, but just to remind us that that part of the bargain cannot be taken away from you. And even in any case, if you use an agreement to convey copyright yourself in the picture taken by the photographer, there is moral rights that sit with the photographer at all times. That is the right of authorship. So somebody made that picture, somebody made that picture happen. There's somebody behind the shutter of the camera or the gun camera, whichever device that was used to capture that image. So you cannot take away the moral rights of the author. So the photographer still enjoys some rights, even if he signs off the copyright of that picture. So he still enjoys the right to be recognized as the author of the work, and then the right not to use those pictures in any manner that he would not like. Because as the author, you still have some control, no matter how small. So even if you have signed your interest in copyright, moral rights still retains and they revert in due. For example, for every work of art that is sold out there, I've said this before in previous sessions on our subject matter tonight, that for all of those artwork sculptures that you see out there, for each time those things are sold, there is a fraction of the sale price that goes to the original author. So when you see those artworks sold for $3 million, whatever it is, they call it in Hollywood movies, the original makers of those artworks must still get a fraction of the sales. So no matter how many times sales happen on that work, something reverts to the original owner, and that tells us about moral rights, which I'm introducing tonight for those who do not know before. So by way of observations on the presentations that have been done tonight, slide presentations ought to be richer in graphics, and then less voluminous in text. Because the idea is you're coming to make a presentation, you should be speaking to your slide. You shouldn't have so much prose in your slide. I'll say that again. It is okay to have an entire article, a written brief of what you're presenting. But the moment you compress it to slide presentation, it is okay to have a few words that point you to the next point, that directs you to the next point. So you shouldn't have the liberty to continue to read to us from your slide. You can always refer us to the prose that you have, because the idea is people get bored when your slide is too cumbersome, get really boring, and people will stop following you. But if all we hear is your audio and what we see are graphics, images representing what you are saying, it ensures that we are carried along. We all can read from different devices or from hard copies that we printed. So if we have to read again from caught in this web of having so much prose in their presentation. I'm saying this ahead so that the subsequent groups for subsequent quarters can be advised and guided early. And the presentation should not have so much prose. It gets boring for the listeners and for everyone who is listening. So make it concise, make it graphically oriented so that
Mr. Shay, can you hear us? It seems you're frozen.
can really flow with you when you are talking. All right, so in a way to appreciate the work, in order to appreciate the work that has been done by the two groups, I mentioned earlier that even though the topic is the same for the two groups, but there are two different areas of research that were done. Group one took us through copyright law and photographic ownership, blockchain, talking about the merit and demerit. I love so much. And then apologies, I had this call that continues to come on my regular line. I'm supposed to be on DND, but let me just wrap this up in a moment so that we can close this conversation. And then group two, in appreciating the work we've done, took us through the licensing and royalty model. That was top notch. The challenges on online platforms in Nigeria, and then cultural heritage preservation, digital production. And so this particular angle of the conversion of the group two interested me because just 2 weeks ago I delivered a paper on protection of traditional knowledge and cultural expression. So I feel this would have a link with the paper I did recently, and I published that on my Instagram, on my Medium. The link is on my IG. You can already pick that up and read it at your own leisure time. So I wouldn't take so much time. Like I said, so much has been said earlier by Adidimade and Omotayo. I just came into keeping one or two words, complementing the group presentations that have been done also, and then open to taking the few questions that we have before we close tonight. It's been 2 good hours on this call, so let us please make it as snappy as possible so that we can go and have a good night. Thank you.
Thank you so much, sir. We sincerely do appreciate your feedback. Thank you. So moving on, please, we'll just be taking presentation, or rather feedback from Ms. Omotayo, and then we'll be going straight to questions. So Ms. Omotayo, over to you for your feedback on the presentations now. Ms. Omotayo, are you with us? Ms. Omotayo, can you hear us now? Okay. Oh, okay, okay.
Sorry. Yes.
All right. Thank you, Ma. So
Okay.
please, we'd just like to get feedback from you
Feedback on
as the presentation
the second presentation or the
of
first.
both presentation, both presentations, both the first and second.
Okay. Both presentations. I think I like the fact that both speakers had, just like what Shay said. I'm happy he noticed that the fact that they both had one topic. I was thinking I'll read same thing from both presenters, but they seem to diversify this. But I'd just like to employ you, not necessarily a feedback on your presentation, but as lawyers, I think most of you all are lawyers here or law students. I am big on practice. I'm big on, of course, you have to read, know the laws, know the theoretical parts of aspects of this topic or this area of law. But over time, I think you learn more in the course of your real life experience or people's real life experience. So you should just generally know that as a creative lawyer or an intellectual property lawyer, people's experiences would help you understand better what the law really says. And as lawyers, you have to actually always stay abreast with the law. You shouldn't, you can't be making reference to an obsolete law. Yes, God forbid that you know all the laws, but you should know when the law has changed, and you should, stay abreast with that. Other than that, I enjoyed both presentations. And I'm happy someone also mentioned, I think the speaker after myself, she referred, you said was she mentioned the artist that recently, I've missed that, but I was happy she mentioned it. Aside Rihanna, she mentioned a recent artist. That shows that you did your homework very well. So it's not just reading and dropping bullet points for us here. It's good that you read and you see the practical you apply these things that you have learned to everyday or real life issues. That's what makes you a good lawyer or an excellent lawyer, I would like to say. So that's it. And then as in the course of your work, eventually, if you choose to go through this path, maybe because of your practice, you should always, find yourself in the community of people that would help you understand this. So if you say you're an entertainment lawyer or you want to be a photography lawyer, find yourself in the space of these people. So of course you have to be in the midst of lawyers to understand the law, but because I know we lawyers, we like to just relate to ourselves. If you're going to be a music lawyer or a film lawyer, you should find yourself in the space of these people so you can understand their everyday issues. Then you apply your own legal expertise or experience to their own everyday. So you should understand what is going on really in the industry. Don't just focus on just law. So I hope this helps somebody. Thank you.
All right. Thank you so much, Ma, for that feedback. We sincerely do appreciate. So not to waste any time, please, we'll be taking questions from the mentees. We've already had a few questions in class, right? But I can see at some point, Kwan wanted to ask a question. Please, you can go ahead and ask your question, and then we'll be taking questions from the mentees, live questions. So please, if you have a question, you can drop it on the chat box, or you can just direct it straight to any of the mentors. So who will be going first? Who wants to go first for questions? You can indicate, you can raise up your hand. You can also, you can raise up your hand. You can, okay. Okay, I can see, oh, okay, sorry about that. Okay, I can see questions on the chat box.
I think this has been answered
Yes, these
by
questions have been answered.
I believe, or someone.
Yes, so please, do we have more questions from the, do we
Maybe
have more questions from the
this,
mentees?
kindly provide the where is this going to be published on YouTube? This
Yes,
particular,
ma.
okay. So if the person missed the answer, they can actually watch it again, right?
Yeah, we'll be posting the links on your group so that you can all rewatch the session. So please, do we have more questions from our mentees? More questions? Nobody with any question?
If there's no
Okay.
question, I think we should wrap it up.
So, in the absence of any question, I want to say a big thank you to our mentors on call, Ms. Omotayo, Mrs. Omotayo, and then to Mr. Shea for such a wonderful and interactive. Is someone trying to say something? Okay. We want to thank our mentors for such a wonderful and interactive session. We really appreciate how you put your words in simple to understand speech that we could run through and we could understand. Thank you to Mr. Adedumade in absentia. Well done to every mentee that was able to stay to the end. We have officially come to the last class for the entertainment, business, and law class, but then we'll be having subsequent combined class with the mentees. Do not forget to share what you have learned, tag our mentors, show them some appreciation. You can reach out to them. Mr. Adim Dumade dropped his email and some of his other details on the presentation. You can kindly look at to that and reach out to him if you have any issues or questions that you would like to raise out with him. You can follow Ms. Omotayo on my digital lawyer on all her social media platforms. I'm sure she will do well to kindly respond to you. And also, if you want to just basically have a conversation with her, I'm sure you can reach out to her. And also to Mr. Shea, you can also follow him on LinkedIn and his other social media platforms. Good night, everyone. Not to waste any other words. Good night, everyone. Please enjoy the rest of your day.
It was nice having you. Bye.
All right, bye-bye, Matt.